I went through the dry run. Interesting. Alrighty.
Was she messing with you, controlling?
Must be. That Jen, you can't trust her. No, never mind. She's the head of the boards. All right. Ladies and gentlemen, thank you for attending tonight. It's Tuesday, September 31st, and this is the Zoning Board of Appeals meeting here at the Parsons Field Municipal Building.
30th.
Sorry, 30th. Thank you. Tonight, well, first, we'll, can I hear a call to order?
Second.
Second. Determine a quorum. We have four folks. We have our quorum. And as usual, we, just to make sure there's no new conflicts of interest, where none of us are related to anybody of the parties. We have no financial gains in any or loss in any of the work that we're about to consider. So none of us have a conflict of interest that we're aware of. Excellent. The first appeal we're going to look at tonight is the 04047 LCC, the administrative appeal request for the nature of the appeal is the planning board approval of the Silver Therapeutics of South Portland. The parties to the action, the appellate is 04047 LCC, and the plaintiff is Silver Therapeutics South Portland LLC, which from here on in we'll call Silver. And unfortunately, as I mentioned earlier, the planning board and the CEO is not in attendance tonight, but that should not keep us from moving forward. One of the activities tonight is to have a public hearing, and as part of the public hearing, we have sent out notices to all the abutters, and we have the list there. Those were mailed on 9/18/2025, as you can see from the agenda. And the notice of this public hearing and meeting was put in the Your Weekly Shopping Guide, our local little paper, on 9/22/25. Having said all that, I would open the floor now to any testimony, public support, opposition. I do request, actually, one other point of order. I request kindly that we respect everybody here, that you turn off your cell phones, please, or at least put them on silent. Excuse me, sir, could you just sign in, please? Just so no one's getting disturbed in the middle of any discussions. And also, when you stand up to speak, please state your name, and if you have a particular standing, we'd like to know that as well, but more importantly, just tell us your name when you stand up. So having said all that, I open the floor to the public hearing aspect. Anybody?
Chair, just one, I think, if you don't mind, point of order.
I'm sorry.
So just some housekeeping. As I mentioned, sort of at the completeness hearing a month or so ago, and I think the board's aware, but this is also for the benefit of the public. You're sitting in an appellate review this evening. So what you're looking at really is the record as it existed with the planning board. So as people make testimony, the testimony should be to the extent that it is about the record from the planning board. So that includes what was submitted as part of the application, but also if the video would also be deemed part of the record. I think before you start taking testimony, I think we should do a little bit of housekeeping in terms of determining, because there have been some arguments raised or discussions raised regarding some jurisdiction, as we would take the whole thing, but because some of these individual issues before you get into the actual merits have been raised, I think it would be prudent to sort of take these sections by section to make sure this board feels as though it can check the box on jurisdiction, can check the box on standing before getting into the actual merits. So I would recommend maybe breaking this into sort of bite-sized pieces and let the parties sort of address those issues first, because if you don't get past sort of a jurisdiction or standing issue, the rest of it sort of falls apart. So that's how I would recommend. It's will of the board to take it how it pleases. But to the extent that any written testimony has been submitted, again, it should only be taken into account as to the extent that it was part of the addresses, anything that's in the record. There should be no new information presented at tonight's meeting.
Very good. Oh, and by the way, I apologize, I haven't introduced, this is counsel for the ZBA. It's Brendan Mazer, who was just speaking, and Teddy Simpson is with us as well. Okay, very, very good. Can you help us go through that?
So I think the public hearing has been open, but I think before you take the public testimony, specifically, I think a discussion of whether or not you have jurisdiction is appropriate. I think hearing from the appellant, I think we can probably clump the sort of checking the box in jurisdiction, timeliness, and standing issue in one piece. So I would I would start with give the appellant the floor to address just why they believe it's the appropriate venue, you have jurisdiction to hear the appeal, and standing. And I think we're going to want to make sure the record's clear, and there may be some follow-up questions that we ask either the appellant or any of the other commenters.
Okay. Okay. With that, we open the floor to the appellant, the representative.
Good evening. I'm Tammy Snell. I represent the appellant 04047 LLC, as well as Christopher Godomsky, who is the sole owner of that LLC. And I'd also like to clarify, a question was asked before the meeting started about whether this is for medical or adult use cannabis. It's an adult use cannabis store.
Only, okay.
That's what the conditional use permit was issued for. So first I'll start with jurisdiction, and I'm going to read because I want to make sure I hit everything on this. So this board does have the authority to hear this appeal under the land use ordinance, Article 6, Section 3A. That says an administrative or variance appeal, and this is an administrative appeal, may be taken to the Board of Appeals by an aggrieved party from any decision of the code enforcement officer or the planning board. So this is, my client is the aggrieved party. This is a decision of the planning board. Such an appeal should be taken within 30 days of the date of the official written decision appealed from. Now, the Silver Therapeutics is likely to argue that you lack the authority of the jurisdiction because the appeal was filed before the planning board issued its written decision. So here's what happened and why you do have the authority to hear this appeal. The planning board voted to approve Silver's conditional use application on May 21st, 2025. We filed our appeal promptly after that vote. The board didn't issue a written decision until August 17th, 2025, so almost 2 months later, the board issued its written decision. However, the board did have an oral decision at the May 21st meeting approving the conditional use permit. Legal precedent holds that appeals filed before a written decision is available are considered effective once the written decision is issued. If we look at the main rule of civil procedure 2BA1, which applies to courts, admittedly not to an administrative body, but it states that the filing of a notice of appeal before announcement or entry of the judgment appeal from does not deprive the court of jurisdiction to determine the appeal. This principle applies to the Superior Court appeals, but by analogy, it applies to an administrative appeal like this one because there's no law on that. So we look at what governs the courts. The Federal Rule of Appellate Procedure 4A2 states that premature appeals are treated as filed on the day of or after entry of the judgment. So the entry of judgment would have been August 17th, according to that. So treat it as filed on the day of or after the entry of judgment. Multiple state courts follow the same principle. The Tennessee Rule of Appellate Procedure 4D states, a prematurely filed notice of appeal shall be treated as filed after the entry of the judgment from which the appeal is taken on the day thereof. So that would put it as being filed on August 17th. Florida Rule 9.110.1 provides that if a final order is rendered before dismissal of a premature appeal, the premature notice of appeal shall be considered effective to vest jurisdiction, meaning that you have the jurisdiction to hear it, even though it was filed prematurely. California Rule of Court 8.406D provides that premature appeals may be treated as filed immediately after the rendition of judgment. So again, that would be, it would be considered filed immediately on August 17th. These court rules provide guidance for this administrative appeal. The principle is consistent. Appeal deadlines serve to provide finality and notice, not to create technical barriers for parties acting in good faith. We filed promptly after learning of the board's decision. The written decision was issued on August 17th, 2025. Under these principles, our appeal is considered filed on August 17th, 2025, which makes it timely within, the 30-day appeal period. You do have the authority and the jurisdiction to hear this appeal. Would you like to ask questions on that before I go on to standing?
No, I don't really have any questions. I mean, I realize you're citing a lot of, other states. Do you have anything regarding that, regarding what the state of Maine
Yes.
has?
Yes, so that's the main rule of civil procedure 2BA1. That states that the filing of a notice of appeal before announcement or entry of judgment appealed from does not deprive the court of jurisdiction to determine that appeal. So Maine says the same thing.
Okay. Thank you.
So it's a pretty established standard across courts and across states and federal.
Will we be able to ask questions of the appellant after we hear from the
Yeah,
other side?
yeah.
Okay,
Yes.
great.
So you, however you want to handle it.
Excellent.
It appears to me, and again, I'm going to appeal to our legal counsel as well, that you do have standing, that's not an issue.
This is jurisdiction.
I'm sorry, jurisdiction, sorry, wrong word, jurisdiction.
I would wait to make any determination until you've heard. So what I would say is allow the appellant to address the jurisdiction, which, and the timeliness, which I think she has addressed those two things, and the standing/waiver
Okay.
discussion that has been raised, which I can help maybe try to explain. It's sort of nuanced, two prongs to the same idea, and allow her to present, Attorney Snow to present, and then allow any of the interest parties, and then you can go to the general public if you feel necessary on just those three issues. Not getting into the merits, not getting into anything else, because I think the board needs to determine those three things before they take on any of the merit issues. So I would allow Attorney Snow to continue through to touch upon that standing waiver issue, and then open the board to anyone here representing the interested parties, including Silver or the town planning board, and then go to the public.
Okay.
That sounds good.
So standing, Silver contends that we don't have standing to bring this appeal, saying that the objections weren't raised in front of the planning board. We participated both orally and in writing before the planning board. We attended the planning board hearing, we spoke, we submitted a written letter to the planning board before the hearing. This participation establishes the right to appeal. There was also substantial public testimony about infrastructure adequacy during the planning board proceedings. Citizens raised specific concerns about sewage capacity and site plan compliance. An abutting property owner, 04047's landlord, specifically raised the septic issue before the board. The planning board recognized these infrastructure concerns as important. The board made specific findings on sewage capacity under the Land Use Ordinance Article 4, Section 3BD in its decision, finding that, quote, municipal or other facilities serving the proposed use will not be overburdened, end quote, and that sewage systems have adequate capacity. By making findings on infrastructure adequacy, the board necessarily considered and ruled on the sewage capacity issue, which means this issue is preserved for appeal. The board cannot make required findings on an issue and then claim that the issue was not properly before it. The public participation in the planning board proceedings, including specific testimony about the infrastructure concerns and site plan compliance from abutters and other citizens, demonstrates that these issues were properly presented by the board. My client's participation in the public process, combined with the board's findings on these issues, preserves all substantive challenges for appeal. We do have standing for this appeal.
I don't have any question, comment. Brandon, anything that?
I don't think at this, I think it would just be appropriate to allow
The discussion.
next, and then the board can deliberate, and I can answer some clarifying questions on, I know that there've been, in some of the correspondence, there's been a lot of legal terms and this idea of standing and waiver, and so happy to try to clarify that when you guys get into your discussion.
Thank you. We will definitely require that. I'm an engineer, not an attorney, so I apologize. Okay, very well. Thank you. Next, could we hear from the appellate, please?
So that the applicant and the appellee, that would be me. I'm Zach Brainline. I'm the attorney for Silver Therapeutics. Happy to address those issues. I just want to start with what I think your ordinance requires you to do tonight, which is when you sit as a zoning board of appeals, you're sitting in an appellate capacity, right? You are you're not sort of looking at the issues anew or fresh. You are deciding whether what happened at the planning board level was the appropriate procedure, whether the planning board made any mistakes when it applied the ordinance, and whether there's just evidence in the record to support the planning board's findings. That's important because it goes to standing. And look, we can talk about timeliness. My point about that is that I think it's just a little strange to file an appeal before the appellant, the party appealing, has actually seen the written decision so that it can sort of cite what's in the written decision and understand like exactly what the planning board wrote down and appeal on that basis. It's just a little strange, that's all. The standing question is I think more important. When you sit in an appellate capacity as a zoning board of appeals, right, you're looking at what the planning board did. You got to make sure that what it did was correct. Under like well-established main case law, a party that seeks to appeal a decision by a planning board up to a ZBA when the ZBA is sitting in an appellate capacity, that party seeking to appeal has to have raised the specific objections at the planning board level that it wants you to address at the appellate level. That's because it needs to give, the party seeking to appeal needs to give the planning board a chance to address its specific objections and preserve it on the record for your review. So right, when you're looking at what the planning board did, you got to look at, did they hear an objection from the appellant on this specific issue or question? How did the planning board come out on that specific objection? And then it's preserved for you to take a look at this level. And that's why it's really important. In fact, it's essential to any appeal that the party seeking to appeal have raised the specific objections at the planning board level that it seeks to bring to you. It's not sufficient to have the planning board to have had a general discussion of the issues. It's not sufficient for another party to have sought to appeal. If another party raised an objection and didn't appeal, then it didn't appeal, right? The party seeking to appeal had to have raised the objection to the planning board. When you go through the record, there are not the specific objections from Zero LLC at the planning board level that it's now seeking to raise with you. So it didn't preserve those objections, didn't give the planning board a chance to have a discussion about and make a finding on the specific objections it seeks to raise now before you. That's a waiver of its right to raise those objections to you tonight. And so for that reason, it lacks standing. And I would just point out that I think if you've all seen the letter that came in last night from Attorney Snow, I think it tellingly doesn't cite in the record where Zero would have raised these objections at the planning board level, because it didn't. And so just as a real sort of gatekeeping issue, unfortunately, when a party doesn't raise objections to the planning board, as Zero didn't, it's just prohibited from bringing in a few of those same objections to you. So that's our argument on standing. I'm happy to address any questions from the board.
So you're saying specifically that Zero did not make any concerns to the planning board during the meeting or in the applicable times that we are allowed to review, that they said nothing about infrastructure?
I'm saying they didn't raise the objections that they're seeking to raise with you at the plan. They didn't raise those specific objections at the planning board level.
Can you tell me specifically what that is?
Can you clarify? Like, what do you mean specifically?
So I'm trying to nail you down to say exactly what you're saying they didn't say.
Yeah, so there's no objection from Ms. Snow or from anyone from Zero about the sufficiency of the findings that the planning board was going through, the process that was employing, or the sewer wastewater disposal systems at the facility. There was certainly discussion about those issues, and there were other people, public comment about that, but that's not sufficient to confer standing on the appellant, Zero in this case, to raise those issues to you. If it were, put it this way, if an issue were preserved for your review, just because it was discussed, then like every issue would always be preserved for review. And that's not the way the law works. The party seeking to raise the appeal to you has to have given the original decider a chance to address their specific objections.
What do you think about what he said?
It's not, I think.
From a legal standpoint?
You are sitting in that quasi judicial role. If you have specific questions about the interpretation or about any of the terminology, I'm happy to opine.
So I guess, yeah, the question is, since it was brought up in general at the meeting, but maybe, and I'm not saying it wasn't, but maybe it wasn't by Zero, is that true that, in your opinion, in your interpretation of the law?
So this is where I was getting at. There's sort of two prongs here for standing. I think there's the question of general standing per the ordinance to be here tonight, as well as the issues that are being raised. I think, as I mentioned, the video, I don't know if this board has reviewed the video, but I think it's for this board to determine whether or not the issues that are on appeal tonight were raised by the appellant somewhere in the record. If you can, either the appellant or this board can look at the record, because that's what we're looking at. We're looking at the four corners of the record. We looked at some case law, and this idea of waiver is in the case law. Whether or not on a general preservation is, I think, unclear. I think Attorney Brandwein has raised the question of anything that was discussed is preserved, then anybody can appeal. And I think it would be prudent to just understand what, so under the ordinance, and this is getting into a little bit of a secondary thing as well, to, I think, both attorneys, how you're here tonight, so you're here to decide an administrative appeal on an appellate basis, whereas an alleged by an aggrieved party. And an aggrieved party is a defined term in the ordinance. So an aggrieved party is a person whose land is directly affected by the grant or denial of a permit or variance under this ordinance, or a person whose land abuts or is across a road or street or stream from land for which a permit or variance has been granted, or is within 500 feet of the property for which a permit or variance has been granted. So I think also for standing, you need to make sure that the appellant, and I think Attorney Snow has hit on some of these, but is an aggrieved party as well. So I think don't have enough evidence to determine whether or not the issues were specifically raised by the appellant. I think you can certainly ask follow-up questions. I know there's also the attorney that advised the planning board that can also, if they're technically part of the interested party, so I don't want to cut off sort of the process we were going in. Attorney Franke may have nothing to say on these issues and at this point, but
If the board's done with questioning for Attorney Brandon, I'm happy to stand up and say my piece, but
it may be worthwhile to hear from the planning board about what's in the record and what is the record.
Yeah, so for my peers, I was thinking about asking Zero for their specific example of where to try and rebut against that. I don't know if you guys want to proceed with that line of questioning, or if we want to hear from all parties and then do that, or.
I would agree with you. I think you have an excellent point there. And yep, I support that 100%. So.
Does that sound good to you guys?
You there?
Is that appropriate to ask?
It's, I don't, we're sort of doing things very methodically, so as long as we're still sticking with the standard, if you want to ask a follow-up question, I think that's fine. If you want to let all interested parties be heard first, because they may be able to, it may change your question, so it may be more efficient to hear from the attorney for the planning board before you ask follow-up questions. That way you sort of have heard at all of the arguments before getting into questions. That seems to be maybe more efficient.
Okay, I think I might just ask the one question to Zero specifically, if that works for you guys.
That would work.
Okay, so do you guys have something from either the planning board meeting, the minutes, or your specific example of where you guys address specifically the infrastructure or septic system concerns?
Not in front of me. It was a long planning board meeting. And this issue was raised many times. I have to rely on my memory. I know that it was raised specifically and very thoroughly by the landlord of my client. So the James owned the building, and they had very specific, very clear objections or concerns about what was being presented and about the sewer plan. I would have to go back and look at, it was probably a 2-hour meeting, to find out if I ever stood up and reiterated that. I can't say that I did, but very clearly, the issue was raised several times, very thoroughly discussed, and the planning board had a discussion about it. The findings address it. So the whole intent is that someone can't just raise an issue that the planning board had never discussed. That is absolutely not what happened here.
Do you guys have any concerns about the aggrieved party with them not being a landowner? Should we try and get clarification about that?
I can clarify that.
I was gonna ask our counsel first. When in the ordinance, you talked about the aggrieved party, you didn't mention theoretical business that might be in that place. You did mention a landowner.
It says a person whose land, so again, only trying to remain within the four corners of what's in the record. The appellant here is presumably a lessee. I don't know if that was as part of the application. But I think it's also important to note that the application is only filed by 04047. So that gets into that waiver question of whether or not somebody can step into the shoes of somebody else for an appeal. And if anything is raised at a meeting, can anybody raise it again? This is somewhat different than, I think, just a preservation for purposes in a court setting. So it's your ordinance and your interpretation. It's again.
May I hear you just very, very briefly on a question about the ordinance?
Sure.
Thank you. Discussion about aggrieved party. The aggrieved party and the appellant have to be the same, right? And so the aggrieved party and the appellant have to be the same entity, and that entity has to have raised the objection. So it can't just be that there are generally aggrieved parties and the appellant can sort of appeal on their behalf. I think the ordinance is pretty clear that they got to do the same. So that's, thank you.
Do you mind rereading that ordinance? I don't have it.
The definition.
Yeah.
Aggrieved party is a person whose land is directly affected by the grant or denial of a permit or variance under this ordinance, or a person whose land abuts or is across a road or street or stream from land for which a permit or variance has been granted, or is within 500 feet of the property for which a permit or variance has been granted.
Tom,
Pretty broad.
I have a couple of questions. Do we have minutes from the planning board meeting?
They're available on, I didn't bring them, but they are available on, on our website. I don't know how detailed they are.
Did you attend that meeting?
The planning board, no.
Did you attend the planning board meeting?
I
No.
would suggest asking them.
Yes.
So I
He
did
did.
not, I did.
Okay.
I can claim I watched the 2-hour video, but I would defer to Attorney Ferrante to discuss how the planning board proceeded, and I think that.
My question was Saco River Corridor Commission have a representative there because of the septic and the water and shoreline zoning and all the other stuff?
So Cameron Ferrante, I'm the town attorney. I'm here just tonight on behalf of the planning board. You guys have your own attorney tonight because of the fact that I was involved in the approval process. But I think we're getting a little ahead of the jurisdictional questions. But to answer your question directly, the Saco River Corridor Commission was not there. There was a condition of approval attached to the Silver Therapeutics approval that required them to obtain the necessary permits from the SRCC prior to the conditional use permit going into effect. But I don't believe that specific condition has been challenged here. I think it's primarily just the board's finding respecting the adequacy of the sewage or the septic system. If I could just quickly jump on the points that have kind of been raised here. I think it's helpful to understand both the context in which, all of these applicants and parties came to be in the same room together, and also kind of the two issues that we're dealing with first here. So the planning board heard 3 applications for 3 separate conditional use permits for 3 separate marijuana businesses that night. The first on the docket that evening was Silver Therapeutics, so they had their public hearing first. Public had an opportunity to speak. The Silver Therapeutics had an opportunity to speak and present their concern or present their application, respond to any public concerns, things like that. And the issue that we're obviously discussing now is jurisdictional, whether the appellant tonight 04047 has standing to bring this appeal. So there's kind of 2 interrelated questions, standing and waiver. There's the aggrieved party provisions in the ordinance, which Attorney Snow read out. Generally, an aggrieved party, it's defined in the ordinance, so it's up to the board to interpret that. That's your right and your authority here tonight. But generally, aggrieved party, as that's used in courts in the context of like an ADB appeal, 1 level up from where you guys are, would be to say that you can be aggrieved in that, your property interest or your property rights are somehow affected by the issuance of the permit. And then there's the party question. And what is a party? Who is a party to any proceeding, to a planning board proceeding, to a board of appeals proceeding? And that's usually a person who's defined as a participant and has participated throughout the administrative process. There's precedent out there that says that you have to, you don't necessarily have to attend. You don't necessarily have to be there in person. You could be represented by an attorney, by an agent, by someone who's just authorized to be there to represent you. And there's, contrarily, case law precedent out there that says that, submitting a comment to town staff outside of the context of a planning board proceeding, who then, reads it into the record or indicates that, I received this communication, doesn't necessarily satisfy the party requirement. So there has to be someone who's actually authorized there to speak on your behalf to convey your concerns or your objections or your issues to the board. And that's how you demonstrate that you've been a participant in the proceeding that's on appeal. Here, I think, there's a reasonable question to be raised. I haven't seen anything suggesting that, these issues were raised with respect to Silver's application through written submissions prior to the planning board's hearing on May 21st, or raised by Attorney Snow or 04047 during the public hearing portion of the planning board's meeting that night. I'm aware that the Jangs made several public comments and, spoke about their concerns regarding the septic system. But I don't believe they ever indicated that they were authorized to be or were acting as a representative or an agent or in any other capacity than as private property owners, the owners of an adjacent property. They didn't indicate that they were speaking for 04047, and 04047 never really joined in those concerns and issues that were raised regarding the septic system. So that implicates these two issues that we're talking about, whether they are an aggrieved party, both under the ordinance and as it's commonly understood and applied in Maine law, and also whether the issue has been waived, because even if they are a party and they participated in the proceedings somehow, they still would have had to have raised the issue themselves. And here, where there was no apparent participation during the public comment phase and no objections raised during the planning board's deliberations or anything like that to the septic system or the adequacy of the septic's design, I think, it's reasonable for the board to consider whether the 04047 actually has standing to bring this appeal. I think there's a reasonable case to be made that they don't. I don't want to trample on Brandon's shoes or anything, but I would ask if the board does find that there is no standing to nevertheless proceed with findings on the jurisdictional and the remainder of the issues that are raised regarding the septic system, just because I want to avoid a situation in which, this ruling somehow gets appealed up and then we have to remand it back for the Board of Appeals here to conduct some, final administrative hearing so that the 04047 can effectively move to Superior Court. So you can discuss that with your attorney and whether you want to go through that process here tonight if it's not truly necessary. But I would just want to request that happen if you do find that there is no standing.
Well, thank you. The reason I asked the question is I believe in the initial form that was sent to Saco River Corridor, the application, the Saco River Corridor either tabled it or denied it. And I just read recently where they did more inspections downstairs in the basement and found some issues down there. So that's why I was asking.
Yeah, so I can't speak to any of that. I would just say that we're really only concerned here with what was before the planning board that night. So it would have been the evidence that the board actually had the ability to
Got
review
it.
and use as a
Yep,
basis
thank
for
you.
this determination. So
We didn't send the emails. Saturday night.
No.
I would hold off until the board has requested further public comment.
May I respond to that?
Yes, please.
So I would argue that the Jangs, as the landlords to 4047, were acting as an agent of the applicant. They own the property. The company has a lease on the property. They were speaking on behalf of their tenant. You need to understand that there's a competition going on here. And I don't know how much you know about what's going on with this, but there's a competition. We have two applicants for an adult use cannabis store. Both applications came in almost simultaneously. Both have been going on this parallel, trying to get to the first one to the end line. Both cannot get an adult use cannabis store license because there's a 750-foot buffer and they're too close together. So this has been a long, ongoing process with a lot of appealing and a lot of back and forth and just, it's been a very long process.
I'm just going to caution getting too far askew from.
I want them to understand the back.
We are limited here to the four corners of the appeal of what the planning board did. We're not here to talk about licensing. It's just the condition of approval licensing happens after. So we really need, I'm just going to caution everybody in the room to stick to the record being in an appellate seat. Not to cut you.
This is explaining why the Jangs would be considered an agent in bringing forth these issues. The Jangs had the same interest as, and represented the interest of 04047.
It may be prudent for the board to ask for specific evidence within the record to show that.
I was just about to ask that, yeah. Is there any evidence of that lease? Does the planning board have any awareness to that from their previous proceedings or the meeting that you're aware of?
So on May 21st, I believe, what was presented to the planning board in the context of 04047's application, not in the context of Silver Therapeutics public hearing or the planning board's deliberation on that application, was basically like a letter of intent to lease. And there were objections raised at the time as to the sufficiency of that letter to demonstrate a legally binding relationship between 04047 and the Jangs. But that was because of sort of a similar jurisdictional issue involving right title and interest and whether the planning board could proceed with its review. Ultimately, the board chose to accept it and proceed, basically conditioned on the submission of an actually executed lease agreement. I believe that's my recollection. I don't have the
Has that
determination.
that happened? Has there been a lease agreement?
I can't speak with respect to that.
Again,
But we're outside the.
there were, as I think Attorney Snow and Attorney Ferrante mentioned, there were 3 different applications that night. We're only looking at the one. So anything that was discussed during a public hearing for the second or third is irrelevant to the record that's here tonight, if that makes sense. So anything that went on the record about right title interest, a lease that was heard by the planning board in the second application, it doesn't get sort of transferred to this wood application. So again, I think base your decision on the record.
And again, I mean, it's my understanding based on my review of the meeting video and being there that night that, at the time of the public hearing and the planning board's receipt of comment, there was no representation as to the interest between the two. The Jangs identified themselves as the property owner, but I don't believe 04047 ever joined in or spoke up and said, yes, we agree, basically.
Okay. Sticky. I'll put it before do we need to review the tape of the planning board meeting to give us any clarity? Because,
I guess the question is, have any of the board members?
I think I've watched it, in preparation for the last one, but I don't know if you guys watched it or.
I've watched it, but not enough to remember specifics to now that we have more information to look at the specifics of that tape and the transcript of it for information to help with making a decision.
So Tom, since we don't seem to be having any comment from the public, do you want a motion to close the public hearing?
I think we didn't.
No,
I can't, not yet.
we're just taking the different pieces, piece by piece, before we get into the full merits.
Can I just be heard briefly on examining the record? Thank you. It is on the appellant to demonstrate that they have standing, that they haven't waived. So they do have to come before you. It's not on you to search through the entire record. You do have to familiarize yourself with it. But it's on the appellant to say, this is where I submitted my objection.
And again, forgive me, I don't believe I've heard that yet, that yes, they did objection at the right time.
Well, I think that's ultimately a determination for you all. Our position is that they did not. And I think what you've heard is that they're attempting to rely on their landlord's objections, but there was no representation to the planning board that I certainly remember at the time that the landlords were speaking for 0.
Yeah, okay. Well, sounds to me like they may not, to jump to the end a little bit, it may sound to me like they do not have the standing because they did not, they didn't represent, they didn't have the right representation, they didn't make the right claims and objections during the planning board session, so I would say they don't have standing.
I think that's a fine starting point for your discussion.
Would you folks have an opinion or need to, think about that some more? Because it appears they didn't, from what we've heard here from the parties, that they didn't do the right thing at the right time. And so therefore, they do not have standing, in my opinion.
Well, we heard it from the lawyers. It's a public hearing, right? Does anyone else want to say anything before we?
If you're gonna open it up I would limit it just to
Yeah.
jurisdiction and standing issue. But it's, again, we're only supposed to be within the four borders. It's perfectly fine. This was advertised as a public hearing. I think to be prudent, you can certainly open it up to, on those specific issues.
Okay, my name is Jeff Wright, from Parsonsfield. I'm really not too sure what this is about. I'm an appellate and plaintiff, but I don't really know what it's all about. And I noticed that all the board members said there was no conflict of interest. But if a person is on the Saco River Commission, would that be a conflict of interest?
No? How so? I mean,
Again, that's up beyond.
yeah, that's way beyond the scope of what we're here for. Yeah.
Okay. All right, well, I guess the only thing I can say is, before you vote, each one of you have to explain your reason why you voted that way. That's in the book.
So we'll have no problem with that if we even get to that tonight, so. Yes,
I'll speak now. Sunday, I.
I'm sorry, could you just, your name, please?
Yeah, this is Michelle Jan, we're the landlord. So we actually I added on top of Tammy Snow's Sunday night, I sent an email to the board. So to explain the septic, so I'm not sure if you added that.
Yeah, we have.
And also, you talk about planning, I have a 20-second, I recorded this in the planning board, if you allow me, I'm gonna play, it's only 20 seconds. Planning board.
I don't think we can get it on the record, so I don't,
Yeah.
I would recommend not. And we can't take new information into the record.
The two things, one of the conditional, this ordinance requires applicant demonstrated applying to certain the deadline here. The septic system was usually installed after June 30th.
It should be the merits.
Yeah.
I would recommend holding off until you
You
get.
already know that? And also the septic system,
Well, unfortunately, we're at the point where we're just trying to determine waiver and standing. So you have to keep the comments towards that specifically, not the merits, not the septic, not the kind of that stuff, but whether or
so I
not.
don't know when or where is the right time to brought up, and because I didn't know, so we filed appeal from the state. Because the septic is clearly designed, identification is a lot of wrong. So, like I say, because every time I brought to the selectmen board, they said that, no, sorry, it belongs to the planning board, and now I brought to and they brought me into this, to the.
Okay, I don't, yeah, I don't, I think you're making some excellent points, but that's not what we can consider at this point.
Selectmen board taught us to come here.
When we open it up to the public commentary for that stuff,
Make
we
comments,
can.
yeah.
But this is just very, very narrowly scoped to the standing in the waiver.
Yep. That may come later, that may come later, but.
Yes, my name is Scott Mouse. I was at the meeting that night, and from my recollection, it was very, it was determined, it was agreed by the planning board that 040 did not have standing as far as a leaseholder. They didn't have right title or interest in the property. So that's a condition that the board, the planning board, approved the conditional use based on.
That's on the, we've already addressed, that's on their application. This is on Silver's application, which is a separate state. I think you're confusing the two issues for what was raised during their application, which was a separate hearing. The planning board took up three things that night. So again, that right title and interest was addressing Zero's application.
Thank you.
Yeah, thank you.
But good point. Just we can't consider it.
Okay, so,
I had some more procedural
oh,
questions.
please,
If we don't find that they're standing, what is moving forward? And I know the council brought up.
This is where Cam's gonna hate me. No,
Talk to us about what next steps.
so
look like.
because
To get out of here early.
so the if you don't have standing, you do not need to hear the rest of the appeal because you're really not supposed to. You don't have the right to per se. There's nothing that prohibits you from moving forward to get to the merits. Again, you're just sitting in an appellate position. What that means is if you stop at the standing question, that could arguably be appealed up to the court for the court to determine whether or not that determination for standing was correct or incorrect. They could say, no, they did have standing, kick it back here for you to get to the merits. So they make the decision basically for us. And then you get into that deliberation. If it's appealed further, which it could be, back to the court, then your decision really, because you're in an appellate and not a de novo review, the court would just look at the planning board's record. Where this is going to get even messier is when you're in an ADB with Superior Court and they're just looking at the planning board record, their definition of aggrieved party and participation and a particularized injury is different than the ordinance here. So they may also have a question of standing at that point because it is a different standard than the sort of appellate procedure here. So what I think Attorney Ferrante is trying to get at is don't have the fight about the standing, get to the, and then if they want to appeal, it's going to go back to the planning board. I think it arguably is a waste of, yes, they could appeal to the Superior Court and we could be wrong. But your decision in that merits at the end of the day will end up being irrelevant. So, but still, it could save some time in the appeal process.
If I may, yeah, I'm just trying to avoid any kind of debate over. So to get to the Superior Court in an ADB appeal, you have to have exhausted your administrative remedies, which means you have to have gone through the Board of Appeals basically. And my only concern and the reason for my request is that I don't want to have this go up to Superior Court on ADB, say that, no, you guys were incorrect, but also because you never reached the merits, there's been no exhaustion. So now we have to kick it back to you. And then it's a back and forth thing. So I understand completely if the board doesn't want to do that because of the potential futility, and you all might want to go watch the wild card series. But I just felt the need to make the request to avoid the back and forth.
okay.
There's no guarantee that it is appealed. I mean, that's the right of whatever party that's, again, aggrieved to further appeal. Again, the decision is the board's. If they want to go through the merits, there's nothing that necessarily prohibits you. It's technically a waste of, it could be technically a waste of time, technically.
Essentially, actually.
Appreciate the candidacy.
So if we do not find standing, that's it. And we have no more abilities to impact any change through this process?
I guess, can you, if you wanted to get into the merits, it sort of depends on what your findings are, and I don't want to have you get into those merits at this point, but when you say affect change, I guess that's a very open-ended
It is.
situation. So I'm trying to stay within the corners. Because the options, if you do get into the merits, there are some options. One, you uphold the planning board decision, you reverse, or you could send it back for more information if you don't feel as though if there's something missing. So those are, broadly speaking, sort
So
of.
say if we wanted to pursue one of those three options, but after the fact that, just during merits, but after we've found no standing, is that,
It's gonna get funky in that situation too, especially if it's sort of not either upholding or denying. I think if you send it back, there's sort of a argument you didn't have the,
what
there's
if
some
we're,
arguments.
what if we're approving or denying then?
It would open up the rights for the other parties to appeal, but again, if they, this is why my personal opinion is if you don't find standing, we stop. That's my personal opinion. I get what Cam's doing because I think it makes it a little messier if you get into the merits and then if they appeal the ADB, I'm not sure your standing question is ever actually addressed. I think, and I defer to the other attorneys. I was trying to mess with this procedural question myself and trying to figure out because I don't think the appeal on the standing question would ever happen if you actually get to the merits. I think it would just be whoever's happy or not happy about the end result would then probably appeal that decision, ignoring the standing question, which would then just defer it back to the planning board. But then I think they could have, depending on how it goes, a party could have the right to raise the standing question in the appeal itself. Sorry, this is a procedural nightmare.
Yeah, can you put that on a flow chart for us? Ian?
So I guess to my fellow board members, I'm not certain that the planning board did, ensured that the septic system was going to meet the requirements. And so although we could not find standing, maybe it's important to address the merits.
I would agree, but I don't believe that the planning board's conditional use permit was required that they had the plan, I believe, for the septic system, but, you know, they didn't do an inspection and so on and so forth. Some of the legal documents in here said, well, they didn't really do their due diligence on.
Before we start getting into some of that discussion, I do think it would be good to close the loop one way or the other. We can still get into this discussion if the board wants to, but I think it would be prudent to sort of close the circle on jurisdiction, timeliness, standard, and standing. And then I think it's reasonable if this board decides amongst themselves to say, even though we have not found standing, we are going to go into deliberations on the other aspects. I think before you actually go into those deliberations, I think there should be a determination that you want to, as opposed to cutting it off. So, and then if you do go into those, I think we sort of open it up to the full discussion at that point and allow presentations on all of it. So rather than skipping over, I cut sort of the discussion by the appellant and the appellee and the town attorney off just on those issues. So you can make a determination if you wanted to get into the rest of it. So you can find no standing and then get into the merits if this board wants to, but I would hold off on actually talking about the merits until,
Okay,
does that make sense?
yeah. Does anyone have any other questions before we make any motions? So would the next step be to make a motion for a vote or procedurally?
We have a comment.
I'm just trying to grasp. How is it that Zero is an aggrieved party? They're not a landowner.
That's what we're deciding right now.
Okay, so that's what I've got.
May I address that? They have an interest in the land. So even though they're not a landowner, they're a tenant of the land.
Yeah, unfortunately, I think we have to stay within the context of that first.
It's what's in the record. I also think, as you're deliberating whether or not you want to get into the merits, if it's helpful to hear from the other, I'm guessing, Attorney Sun may want you to get into the merits. I'm guessing Attorney Brandmeier may not want you to. I don't, it's your final decision. But I think it's, I think you can do it, well, I think we can take, we can take a formal vote on, I think we take them as separate issues. So let's start with jurisdiction. That I would suggest somebody making a motion that you find that this board has jurisdiction over the matter, then take a motion on that the appeal was timely filed, and then take a motion on that the appellant has standing. 3 separate motions, 3 separate votes, and then we can take the rest of it, I think, as a final motion, if that makes sense.
That makes sense to everyone to, okay.
Unless any of the parties have any objection to that process.
I don't have any objection to that process.
Trying to get the record as good as we can.
None for me either.
And I like to hear a motion that we accept the fact that Zero has jurisdiction.
The board.
Sorry, the board has jurisdiction.
I second that.
Second. Approved, all, unanimous?
I'm abstaining.
I'm sorry.
She's abstaining.
Right, because
abstaining.
I felt that the root cause of the whole confusion was having 3 applicants in one evening, and I think this should be sent back to the planning board for more information for us. That's okay. That's 3 of you that said yes.
Well, we're just voting on whether we can hear.
You're not voting on the entire
Yeah.
decision.
So-
So determining that you have jurisdiction to hear it tonight.
Yeah,
Yeah, that's, so, yeah, and I think we do, but regardless, it's 3-1. The motion passes. The next would be on the standing,
Timeliness.
the timeliness,
That the appeal was filed in a timely manner.
yes. Can I hear a motion that, that we vote on whether the appeal was filed in a timely manner?
second.
I also agree. Judy, do you have a?
Yes.
Okay, so all 4 for that. And the final is, that's not the standing?
Yeah.
Okay,
Standing.
thank you, standing. I can't read my own writing.
And this one, I think, giving some explanation so we can get it into the record of why you're going one way or another on either finding standing or not finding standing will be helpful for us to draft the conclusion of law.
Okay.
So as we vote, then go down the line and just describe why, or do we just have a general explanation?
I think a general, I think maybe having a little bit more discussion before you can take the motion.
Yeah,
I would suggest that you take the motion in the affirmative so that there is standing, and then you can vote yes or no. And then before you take the vote, motion second, and then discussion
Okay,
to give us a general feeling of the entire board, because the conclude is what the board finds as so we, and it's denied because, or it is, it's a 1-3 vote to say there isn't standing, so, yeah.
Can I hear a motion to decide on whether or not the appellant has a standing? Can I hear a motion?
Second.
discussion?
Discussion?
Go.
Based on everything I've heard, it does sound like they do have standing. There's without question, some areas that may be a little bit of questioning, but I do believe I do believe that the planning board did do the right thing. The parties that were being represented also did the right thing, and so at the right time. No one's come up and said without question that it didn't work that way, that the videos should clearly proves one thing or the other. I would,
We give, just for the benefit of the record, a little bit more clarity on what's in the record of the appellant's participation in the proceeding for that. Because we're dealing with that waiver question too, so.
okay.
It'd just be good to be able to point to the participation piece.
Okay, for me, it's basically that the first thing is that the planning board failed to make required findings based on evidence.
But that doesn't show that, I'm sorry, and I'm not trying to lead you too much, but the standing question is just about the appellant being an aggrieved party and participating. It's not about what the planning board did yet. That's
Okay.
getting into the merits. It's just,
Right.
do they have the right to be here in front of you tonight?
So maybe I'll give my thoughts.
Please.
Okay. I don't think they have standing. I think the ordinance is pretty clear about land ownership. I could see some discussion as if there was a signed lease at the time of the proposal, but there's no evidence of that inside of that defined time that we're talking about. So in that light, I don't see where they can be an aggrieved party, because they're not landowners, nor do they have that signed lease within the frame of that specific discussion that we are responsible for tonight.
Good point.
Not that there wasn't anything after the fact or outside of that, but we are limited in scope by that specific amount of time. Does that make sense?
Okay, no, I understand that, yeah, okay, thank you.
Yep.
I would change my vote, say that, I would be, they do not have standing.
Any questions about what I was saying with standing or you guys' understanding
I'll
of it?
just say my piece and then be quiet. I think, even though it's, technically they don't have standing, I think that 4 people are here that raised some valid concerns and that they should be addressed. The landowners are here, technically they are not you guys, but you are leasing from them, so, in my head, if there's valid concerns, they should be heard. But that's where I'm going with it. Well, I'm dissenting.
Just, I agree with you, and that's why I wanted to continue on after the standing part.
You go to the merits?
Yep, not trying to change anyone's mind, I'm just
Yep.
continuing discussion.
Okay, go to the merits.
And Tom, he took the words that I was going to say, so
Okay,
I'm all set with that.
okay. Basically, it's 2-2.
Well,
But-
we should
but-
officially vote, right?
Yeah,
So I would, and I tweaking the way you wrote, I suggested framing it, so I would frame the motion as, that the appellant has standing. So if you vote in favor of the motion, you're voting to say that they do have standing. Again, even if you find that they don't have standing, so it could be a 0-4 vote whereby the motion fails. You can still get into, so I'm just trying to address your concern that you don't think there's standing, but you still want people are here, you still want to get in. I think we can still do that.
Okay.
So the motion was that there is standing, so a vote in the affirmative would be yes, they do. A vote in the negative would be no, they don't. So I think it's perfectly fine, unless you have more discussion, I think it's perfectly fine to take the vote now.
So are we good to end discussion and vote?
I'd say, yeah, but
I
we end
appreciate
discussion and vote?
how you just framed it, so yes, I agree.
So do we motion to vote?
yeah,
We've already had the motion.
I'm just
Okay.
clarifying what the motion was.
Okay.
Because the chair said whether or not, and I think it was more, so.
All right.
So,
Good to vote. If you guys are good to vote, let's vote.
absolutely, yeah. You first.
I'm voting. So I vote in the negative of the motion. I do not feel that they had standing for the reasons I described.
I'm gonna go, yes, they do have standing for what I just described.
I'm going to have to vote that they do not have standings based on what the information you provided and also some of the evidence that was provided here. I'm assuming what was presented here was accurate.
Okay.
Yes, no?
We're unanimous, right?
Nope. Nope. It's two yes.
2-2. 2-2.
2-2, okay. So,
So the motion fails as a tie.
it's a tie, so.
So there is, the overarching determination is there is not standing because it was a tie.
Didn't your mother tell you that
So
legs have to stay?
She did.
I then think it's probably prudent to take a formal vote to enter into.
Can I be heard on this point just quickly about whether you're going to get to discussion of the merits? If I may.
Sure.
Thank you.
As long as it's brief.
Whenever an attorney says it's going to be brief, it's going to be brief. I technically, the appeal's over because they don't have standing. And I get the desire to get to the merits, like, that's why you sit on the board, you want to hear about like what's actually going on and you want to help make decisions on that. I think that if you get to the merits, you're going to open a real procedural can of worms here. If you are right about standing, then this is over. If you are wrong about standing and zero appeals, then the Superior Court's going to make a decision all on its own, and it may reach the merits, or it's going to come back to you and you may reach the merits. I think it's better to let that process play out without sort of opening this can of worms by getting into the merits, because you're going to have to cross appeals and you're going to be making a decision that's like really sort of moot because the appeal is over and it's like doesn't have any impact at this point. Again, if you're wrong and I'm wrong and zero does have standing and it does come back to you, or the Superior Court gets to the merits, then the concerns that you may have underlying all of this will get addressed. If not, then you've made the right decision on the standing issue. That's my point. Is I think you should just sort of let the process play out naturally.
Makes sense, okay.
Since we gave him the opportunity, should we give the rest of the councils an opportunity to address that real quick, briefly, please?
Sounds like the fair thing.
Does that fine procedure wise?
It's with the will of, before we, I mean, if you want to.
You should give the other attorney.
Yeah, no, I think it's prudent whether or not you wanted to make a motion to proceed and then but I think taking it now before, because it is technically over, arguably.
I actually agree. I
Okay,
don't see any point in continuing tonight. If we appeal, it's going to be heard at that point. You, at this point, you've denied that the appeal is even valid. So I don't see any point.
Not that
it's
many.
agreeing.
I know attorneys agree.
Oh, sorry, didn't mean to insult anybody there. Well, I guess then, there's nothing else to do.
Well,
I believe unless,
I had another question.
I'm sorry, go ahead.
When you said we had three options, right? Send it back to the planning board, or we could approve or deny.
you get into the merits.
So if we get in the merits, then we have the ability.
You'll have to make a final, you would arguably be making a final decision. And this is what I think I was,
Trying to-
and I think Attorney Snow and I think Attorney Brandwine, and I don't want to speak for attorney. It's a non-decision decision in that it would maybe consolidate the appeal process in that somebody's going to appeal the standing decision, somebody's going to appeal the merits. All it does is if we were wrong on the appeal, you've maybe already done the merits, but there is also a window that it comes back anyway, that you have to redo it because you found no standing. And there are a lot of what ifs here. So that's where the procedural can of worms that Attorney Brandwine was raising occur. I do, again, it's your decision. I think there's an ability to get to the final, to go through all of this, which we will, it'll probably take a while to hear everything and hear the arguments. But
Yeah, I guess like I said previously, I don't feel that the planning board executed correctly.
That's,
but it's different than standing.
that's beyond your scope at this point.
Okay, great.
That's-
All right, that was my question.
Yeah.
Okay.
So I assume then you'll be in agreement for the merits and even take it to a vote, or just, let's just go through the merits and then figure out.
I
think we need-
impact change.
I think the final motion, if you're not going to get into, I think it would be a final motion to deny the appeal due to the
Like a standing.
lack of standing. So one final motion
Okay.
that to deny the appeal, and that'll preserve Attorney Snow and Zero's appeal rights.
Okay.
To take your denial based on that issue further if it decides to do so.
Okay.
So
I'll make, do I hear a motion to deny the appeal based on, the appellant has no standing?
Motion.
Second? So carried the vote. I vote that my vote is that we deny the appeal based on this,
I vote that we deny the appeal based on standing.
based on standing.
Don't agree.
Okay. What's, you know.
I mean, what's
vote-
a tie say? 'Cause it looks like we're heading toward a tie.
A tie means it would not pass. It would, it's the problem when you have four people on a voting.
Right.
So the tie is as good as no.
Okay. All right.
So you're,
Yep.
yes, or yours, yes, or, okay, so we'll,
On the advice of our attorney, I would say yes.
so
3-1.
it's unanimous that,
Oh, sorry, I was for.
Yeah.
Okay. So now here's the other fun piece that all municipal attorneys love. So we've been trying. That's why I have Teddy here. We've been trying to draft these findings of fact, conclusions of law that need to be finalized, printed, signed. We're not doing that tonight, so we can have there's multiple ways of doing this, none of them are great. You've taken the vote, so it's a decision, so the clock is ticking. We can sort of read it out loud and have you approve it and then authorize the chair to sign it on behalf of the board, and we can send it tomorrow. If that works, we can try to finalize it tonight and print it and have everybody review it before we leave. If we have access, I don't know what we have for access to.
how's your timing? Is it everything already blown?
I'm late. The meeting got pushed back an hour and I found out yesterday, so I'm already in trouble.
And we don't have a secretary anyway, so thank you for taking notes.
Yeah.
Well, this one needed to be, I think, a little bit more formal than some of your others.
Yeah, for sure.
How are you feeling, Teddy?
Do you want to continue and just really ruin your night, or do you want to let go now?
So like I said, I'm already in trouble, so.
So just keep it going, try to get it
Wait,
wrapped
if
up?
we could do it as quick as we can, let's go.
Okay.
Well, and I don't know that we should go into merits if we can't impact change.
We're not going on merits.
No, this is just
Done.
getting.
This is done. This is just finalizing
Okay.
with the 3 votes
Okay.
in writing for the findings. You guys, Zach, Cam,
It's up to the board. I mean, you've got 7 days.
I mean,
you have 7 days, so if you want to.
Megan's with him right now.
Okay, then let's,
read this.
Party has-
okay, I agree.
Who shot?
So.
I had it all planned
You
out,
can't DocuSign it or anything?
then they pushed it back an hour.
so
Okay.
if I may,
Yeah.
I mean, my general practice at least is to basically authorize the attorney, the board's attorney, to prepare findings of fact consistent with the board's discussion tonight. Those can then be circulated to the board members for review. You can direct comment back to the attorney. And then separately, you authorize the chair to sign on behalf of the entire board once the final,
We're gonna do that. You've taken the vote, so we've got the 7 days, so we've got
Yeah.
it pretty quick. So by,
so if you all have access to email or are comfortable coming into the town office, talking to
We
me.
do a Dropbox so we could sign it that way?
we're just gonna have, what we'll do is if this board is comfortable, we'll authorize the chair. And that'll be in the final document to sign. Once you guys all approve it in the next 7 days, we'll get it to you by the end of tomorrow. And then somebody here at the town, we can work with the town staff to have it printed once you guys have all approved it. So really looking for all of you to review and approve by the end of the week. And then it can be signed, printed, and provided to all of the interested parties.
Are you available to sign, Tom?
Oh, yeah,
Over the next couple of days?
absolutely, yeah.
Do you guys feel comfortable having Tom sign for us? And do we want to make sure we review it first and then? Tom?
You'll have a chance.
Yeah, absolutely. I'm not gonna sign it without everybody reviewing and giving me an email thing saying, yep, you,
Okay, that is time. That works. We'll go in that direction. So then, you should close the public hearing portion and then move into the completeness determination on the next agenda item.
correct. Yes, we still have one more item to go.
All right, motion to close the public hearing?
Second.
So done, so carried. Now call this particular
Thank you for
system
your time and attention.
adjourned. We have one more. Yeah, no problem, man.
Thank you. Thank you, guys. Thank you.
Sorry, missed you up here, man.
See you guys next. No worries.
Okay. So item,
We're still on the record.
What?
We're still on the record.
Oh, we are?
We
Oh,
have to go to the completeness hearing for the second item.
this is just going through the thing for.
that's that's not too bad.
It should not be.
So again, just like the last time I was with you folks, this is pretty ministerial. It's just making sure that you have enough to start getting into the discussion. Part of the discussion that we had tonight, we didn't get through the full discussion, but is there anything missing from the application that would make it incomplete that you need before we schedule it for a public hearing?
Okay,
Does that make sense?
yeah, which appeal is this?
On the back page, so this is Keyser Falls Millworks LLC, regarding Richard Ying's site plan approval.
What's,
Jesus,
It's on the,
man,
yeah.
so,
it's the last page you said?
Oh, I'm sorry, I'm reading off of the, I didn't print it yet. I have it electronically.
Not it.
So this is
I know I have it in here amongst the
7
dead trees.
administrative appeal. Appellant is zero. Okay, so this is Keyser Falls Mills work appealing the decision that was made for 0407.
So they are appealing, without getting into, yes, it's approving the 0407 conditional use application.
Gotcha. Yeah, I mean,
are we in the public session or executive session?
We haven't,
We're just in the,
getting started.
it's determination, so you,
Yeah, we should call it to order and make it official, but
don't you, yeah, Chair, that's smart. Go through on page 2 of the agenda.
yeah, page 2 of the agenda. Call this, call the ZBA to, calm down, Tom. I call the ZBA board here to order. We have a quorum. There's no conflicts of interest with any of this. So the purpose here is just to review, I shouldn't say just to, but the purpose here is to review the application of the appeal from administrative appeal from 04047 LCC and reporting, appealing the decision, the board decision. It's interesting, the nature of appeal, planning board decision of 0.
This is, for some context, it's the flip side of.
Yes, okay.
Conditional use approval for 0407
Yes.
Keyser Falls Millworks LLC, along with, 2 entities that are related. Keyser Commons LLC have filed this appeal.
I've from my computer. I've already reviewed it, and I didn't see anything missing. All the it looked fine to me. That's not it. Oh, come on, Ed.
I didn't realize I would have had the ordinance. You have the ordinance, Andy? Sorry.
Nope. Let me get to the right section.
I know it's very basic, but
Oh, I see what we're working on. Okay.
How much? I don't remember what section that was.
Okay, I got it here in the computer.
How far into the packet is the application?
it's mostly page 1 and 2
The application itself, yeah, is at the,
for,
Okay, so the first page is the application.
yeah, and then the first and second page is the appeal.
Okay.
And like the reason why. And the thing I was saying is the hardship part and whether that needs to be described or not in the ordinance. I couldn't remember if that's a requirement.
no, not, because this is not a hardship, this is an appeal of a conditional use approval, so.
Okay. So
You're
that part
in, you're
doesn't-
in the administrative, it's irrelevant
Okay.
to your completeness determination, it's not necessary.
Okay, yeah, that's why I wanted
Yeah.
to double check that. Thank you.
And their appeal is a failure to provide proper notice to property abutters, failure to make written findings of fact. That's most interesting.
And then the requirements for the appeal is just literally write it down that you want to appeal, right? Probably.
And pay the money.
Yeah, okay.
And yeah, basically, yeah, they went through the standards and they provided their narrative and they've shown right title and interest.
Yeah, we'll have to, typically, our Secretary Henry would get all the, list of the abutters and so on and so forth.
That's in the packet.
Tom,
Okay, you did that.
can you explain just briefly what this appeal, variance appeal is? Is this for the Stanley Building or is it for, what is it for?
I'll have to see, well, let me see which one, because I'm reading off of.
It's this one, right? Is that the one you're reading from?
Nope, this one is, nope, this is,
Thank you.
what's this one?
This is Scott.
Yeah, this was just filed in 9/2.
That's,
Oh, yes, it is. I'm sorry. Accuser Fallen No Works. Yes, that's the one.
Okay.
Yes, my apologies.
Okay.
I'm used to seeing it on that side. So, yep, they got all the abutters, and all that.
So do we need to officially summarize the nature of the appeal, or did we do that?
no, I think you just need to determine that the appeal has been filed and the application is adequately complete. C2, scheduling a public hearing.
Tom, I guess I have a conflict of interest here because I am also can represent the Riverside United Methodist Church. That's one of the abutters. And we are in favor of this variance. So I guess I have to conflict.
Okay.
Wait,
She's a member of the church. That's one of the abutters. And
What's this,
It was sent to, I'm chair of the church council at Riverside
this is
Methodist
the
Church.
same, and I haven't dug into the description, but this is basically, from my initial review, a cross appeal. So, and I don't want to get into the merits, but arguably if you have a conflict on this one, you had a conflict on the last one.
I don't think I had a,
Because they're just appealing each other's conditional use approvals.
yeah.
They're very close together, properties. So if you have a conflict on this one, it's
I think it wouldn't have
the
changed.
the church did not receive a letter regarding
Yeah, I was-
04.
I was going to say we should
Received it.
look at that particular, look at that variance application and see if the church is listed there. Because you may not have been listed there
Yeah.
because you're not truly.
There's tons of people that were listed, but we were not listed on that initial one, just on this one.
We have a public question. Do we take comments from? the
Not yet.
Okay. Sorry, we'll get there.
Not yet.
Sorry.
Because I don't want to open up until because typically the conflict of interest is determined earlier, so.
I don't see a reference to the church in this current one. Trosh, Gardner, Packard. Where-
If I have a conflict of interest, I don't have a quorum, right?
That's another, if you're going to recuse yourself, then we would need to table this to another when.
I'm sorry, but I don't see the church listed here as an abutter.
It's the very last page.
Is it?
Sorry, next to the last page. I bent the paper down here.
Riverside Methodist Church, it's on page 30,
It's on page, where are the page numbers?
Yeah, ours don't have page number.
37, so it's the fourth to last page, I think. I do see it.
Here, Tom. Second one down.
Is
Okay,
that not on the other one?
So if you're going,
okay, this, I'm curious, because that doesn't match the other one. This list doesn't match the list that's here. That's why it's not showing up on the one I'm looking at.
I've hit, Tom, the lower right-hand corner of the page is bent, so you'll find it.
Okay.
but it might be worthwhile discussing what a conflict of interest truly is, or is this the level of, and if you don't feel comfortable sitting on it, that's fine as well. But typically, just by being a member of an abutter doesn't, if you're gonna represent the church in some fashion in front,
I technically said,
yeah.
I only say that because
But if you're gonna, there may be an appearance of conflict now, given, so if you feel like there is a conflict, then, my recommendation would be to recuse yourself, from this matter.
I'm a little confused because we have two abutters list forms attached here. They're not identical. Yeah, they're not identical because it doesn't, on the first set of forms,
What I would recommend at this point, and I don't think this would be a conflict for you to rule on, would be to find that the application is incomplete.
definitely,
And send it back to address the issues.
yeah, because there's two lists and you're not listed, the church isn't listed on,
And I don't know if this is a clerical error on the part of the town. I have the same documents that you have, so I don't know where, but I would not accept this as complete if there's a question of anything that's included in that application.
absolutely sure I'm not
that's
being
frustrating.
stupid.
It's the town, right? You were saying the town.
I don't, well, I think the town,
prepared the
I just think the
packet.
town pulled it together, but, I would assume it was submitted by the applicant, and I know I don't know if there's somebody representing the appellant here in the room tonight. There was, supposed to be in case there were any questions.
Scott,
Yeah.
his name, he signed the first page.
Yep, yeah, the church is definitely not listed.
I would take, do you have any explanation on the two abutters lists in the packet?
Did you prepare either of the abutters lists?
Our team did. We include, according to the new ordinance, we include everybody in Florida also. Whereas the other parties have not been including anybody in the other town. New ordinance decided that does require 500, even if they're in order. So our list is about double the size of the.
So is there two different lists because one's for Parsons Fields and one's for Porter?
And this has to do with our application.
This is the completeness so we're done with, so this is for your completeness application where, Attorney Grant, I mentioned you were gonna be here in case there were any questions.
Or is one Parsons Field, one Porter?
Yeah,
Parsons Field, Porter.
Porter, okay.
Yeah, that's what I was thinking, is that they did two different ones because there's one for each town.
Yeah.
Okay.
I mean, does that answer your question? I mean,
Okay.
Yeah, it's just us becoming familiar with it because it's so different.
Yeah, that's for sure.
And it's
There's
just,
been a lot of that through the planning board, is, they worked up the new ordinance
yeah,
to include Porter.
yeah.
And so they were like, well, why are all these?
No, that's
Yeah, I mean, you should have put them all in one. That would have been a lot.
No, I would sort of retract my,
Yeah.
There's a map also.
I,
There's a map
so
of Porter side and a Parsons Field side.
it makes sense now. I didn't have the context,
Yeah.
and I don't think I had the context.
Right. But based on that,
I don't,
Makes more sense.
it makes more sense.
yeah.
Can I
Okay.
get that back?
Yep, of course.
Yeah, okay.
And it's got half the town as in a butter.
So I guess we're back to the question of, if, Judy has a conflict and is recusing herself, we no longer have quorum.
So can Judy vote on the completeness and then recuse herself from the next step?
I know everyone wants to get this completeness done. There could be an argument that she shouldn't have voted on it.
Yeah.
I don't, my recommendation would be not, if she's gonna recuse herself from the actual, proceeding, the public hearing, she really shouldn't vote on completeness because she could have a bias on determining that completeness. I know you want to get there,
Yeah,
so I would recommend tabling this to a date certain. If you truly feel there's,
I guess that's the question is, do you feel like there's really a conflict of interest?
We have another church member here too. So I don't know. I don't know what to do. Whatever works. I want to,
this in an unbiased,
I better be unbiased. I'm a retired teacher.
no, but I mean, I'll just you did go on the record and say we favor this already. So you've made some public comments on the application that I think that shows some, at least appearance of bias,
Yeah.
before you've looked at.
Okay.
So
So what would that open us up to if she voted on just completeness? Say it passes in the positive, is there room for
This is a
somebody
weird-
to
I
appeal that
think-
decision for completeness?
this is a fair question. This completeness determination is, it could be. Whether or not it would be is, and then we may be back here, it's sort of, I think it's a question that could be appealed.
Can we seek input from non-board members
No.
as to whether we should vote as?
It's irrelevant. I mean, either, yeah, I mean, you can take,
Like, could I ask Scott and be like, hey, man, do you want to roll the dice and just move forward or not?
my recommendation would be not to take the vote,
Okay,
given what's been said on the record tonight.
so,
I have to wait till,
So I would table this completeness hearing until, and we can, so as a side note, what we tried to do and with Desiree's transition and it failed, we can schedule the completeness hearing and the public hearing for the same evening. There's no reason that we can't advertise them. So we can table this completeness to a date certain when the third board member is here.
okay.
It's just two agenda, just like we had two agenda items tonight, but we'll just go, instead of closing this, setting the date for the public hearing and then rescheduling what we will do, and I'll need your help coordinating with the citizens or the town, so we don't have a advertising issue again. Table it to the same date, we're gonna do the public hearing, deem it complete and go right into it the same night.
Okay, we can't schedule that tonight anyway though, because Erlen's not here.
yeah.
So we should probably wait. So that was gonna be a problem. I don't know how we're gonna, so I think we can I'll work with
Schedule,
Tom.
I mean, can we
But-
we'll schedule?
But we should, what I think would be good is to take a motion to table it. I'm trying to make sure this is a proper motion.
To a date uncertain. Just kidding.
We can do one of two things. We can table it indefinitely with the understanding that we're going to schedule it on the same, this is typically what you would do, would table it to a date certain. We don't know what that date certain is, so we can either table it to,
Well, technically, since we don't have a quorum, we can't even hold a meeting.
Well, we technically have a quorum right now.
Well,
And we
but
can-
she
well,
should,
yeah, that's,
she should be recused, so.
Peeling back the layers.
Right.
So
But
we
can
should,
I think,
motion to table it. I think.
let's,
motion to table it.
let's just, I think you have a fair point, because Judy shouldn't vote on it, and we don't have,
We don't have a
we
quorum,
we
so
haven't opened this.
this is all.
We couldn't open the hearing in the first place.
Null and void.
So with that, I will circle back with, I'm not quite, I don't know who at the town, but Tom, you and I can coordinate. We will schedule this for a completeness hearing and a public hearing on the same date that works for the 3 board members that can participate.
I'd also want some time to look at the zoning map and see, are all these people really, abutters?
So there's nothing in the motion. We can
There's
just
nothing,
close.
we can, I think
Yeah.
I would make an emotion to adjourn the meeting, and I think Judy can vote on that because we're not making any decisions.
All right, I motion to adjourn the meeting.
And I just want for the benefit of the public, Chris, did you understand what we couldn't get to a vote on the completeness. We'll schedule that for the same time as, and I'll work with Ben as well, to schedule for the same night as the public hearing. So I don't think you're losing any time here.
Yeah, also Scott, the reason why
I'm sorry.
we had to move, I had to leave is because there was a mix-up when Desiree left. It was supposed to be at 5 o'clock. That's what we agreed to at our last meeting. Didn't realize I had scheduled it for 6. So that's why he had to bail. And so,
But at least you'd have to come back once anyway.
You're gonna have to,
yeah, I mean, yeah, if there's any consolation.
I think we can
Sorry
set
about
it,
that.
One more time.
I think we can still set it up that you'll only come back once.
Can I
Yeah,
say something?
absolutely.
Because we have a title interest, because one of the planning board is turning, he made us sign these because we have the intent to lease. Because that lease was covered by title interest. And this-
We're not taking any public testimony on anything at this
It's
point.
very wrong, also the select board redirect us into this.
Should we-
don't have any right.
Public, you shouldn't take,
The planning board check on anything.
you folks should not be taking any public testimony at this point.
Can we just have general conversation and, no,
No, the meeting's closed.
Meeting's closed.
You're not taking,
just hanging out in the room?
no, you have a quorum.
Right.
We need to disperse.
Okay.
Thank you all for coming and.
Sorry for the confusion, but I figured I had to do the right thing.
No.
We're following the law.
We shouldn't have any ex parte communication.
Right, yep, absolutely not, yeah. I just wish we had to help explain things.
Conflict of interest.
Oh, if you have to ask that question, you have a conflict of interest, actually. It's, actually, it's, our relatives, financial, religious, anything that could influence, us,
Appreciate
but,
it.
yeah, thank you, folks.
You guys did all the work. So I'll try to get that draft to you by the end of tomorrow, hopefully.
No problem. I will be waiting. Let's see. Wonderful.
I think you just don't forget, Tom, to turn off the meeting.
Sorry, boss?
Turn off the meeting.
Yeah, oh yeah, yep, I'll take care of that. And I guess I gotta figure out how to lock this place up, which I don't have any keys, so that's gonna be interesting. Maybe I'll just have to stay here all night.
He did it.
I got it, Tom.
Oh,
Meeting's over.
thank you, sir.
Have a good night, you guys.
Thank you for your, really pointed and
I hope it wasn't overstepping, that was not my intention.
No,
I just wanted to-
no, God, no, man.
Okay.
God, no, not at all. I'm out of my league in a lot of things, and so, please, don't ever feel that way, man. You blew me away with how you were right in there, you're on top of it, and just, wow. Not that I expect you to be dumb, don't get me wrong, but, no, man,
But as long
appreciate all the
as
help.
we're all on the same, in my opinion, we're all on the same team, so I'm
Trying to
not,
do the right thing, you're absolutely
Exactly.
right, man. So
Exactly.
please don't ever feel you're stepping on anybody's toes or anything like that.
We need to come up with a better mechanism to have somebody communicate to the public. Like the Janes are out there right now and they're upset. And there's a lot of things that we could say to them if we weren't, and we don't have anybody that's helping them
Yeah.
or talking to them. I don't know. We need to figure out a mechanism for that.
That's a common problem I see with all the aspects of our town government. You know, it's just a handoff.
Oh, there's the guy that locked up for you.
Oh, there he is, good. I didn't want to stay all night,
That's all right. I was in my office having a stroke.
you know,
Actually, this is something we should bring up as well. So we have do you have a minute?
Yeah.
Okay. We have a problem where we can't speak to people. You guys probably can't speak to people. But the Janes, right, they have very valid concerns and they don't quite understand what's going on and being said. We need somebody that be able to articulate.
What somebody needs to do is write to them very clearly,
Yeah,
because otherwise people get frustrated with her because she doesn't understand. It's not that she's trying to argue, she just doesn't understand.
right, exactly.
And she doesn't understand enough that I don't even understand what just happened at the very beginning. Like the planning board clearly debated right title and interest with Cam. And their attorney never spoke up. I mean, the whole topic was brought up the first time. The planning board voted that the leasees had right title and interest in the property, and Jen went and got their lease out of the office.
Wow.
So why didn't none of these guys, and
They could have just said.
Jen asked me not to come in here. So I'm sitting in the office with my head exploding, and I was like, we're missing a whole fact here. It's just gonna, it doesn't matter if it's just gonna come back. It's just gonna keep spinning.
yeah, and we're gonna be spending a shitload of money.
Well, I just calculated, we just spent about $750 an hour for them to sit in here for 3 attorneys. Why do they have 2 attorneys? You guys haven't told.
Well, he's just a legal aid.
$250 now. I just saw them go the other day.
But one has to think and the other takes notes.
We should make this to where if people are just gonna appeal, what if they lose their appeal? They should have to cover the town.
Right. Well, and also Cam is representing the select, he's here to supposedly represent the planning board.
Yeah.
But he didn't speak up about the right title and interest, and also how can he represent us if he's representing select board? In the same thing, so it's well, not us, I was on the planning board, but
Right.
there was a lot of questions I had, but again, I stayed in my office, I slammed things a little bit in case you heard, but so it's like, what the hell? Someone open your mouth. Because everybody wants to say something, but they don't want to say it at the time.
Right. I don't know. I am concerned about the septic though. Do you guys have more detailed information? Like, are you concerned about the septic?
I'm very concerned about it.
Okay.
But we were told by the attorney, the town, by Cam, about something to drop the septic issue. Because they asked us for we gave them a conditional approval, which ran out. They knew it ran out, so they went to south of the recorder and got an extension, no, and that was in the planning board. So technically that nullified their initial approval.
Right.
But no one's bringing that up. They're just saying, well, it wasn't started, but it was never inspected and nothing was provided for septic plans.
Right, and I
And so they
know,
weren't going to inspect it, and no one's even going to.
yeah, well, and you need 2 inspections at least, unless it's a pre-approved, septic person. Where's the easement right away? How is all